Welcome to week 3 of evidence, where we are moving on to the topic of privileges. We are covering the cases from your casebook on pages 563 to 590. The first case that we covered was Sweeney v. Dayton. This is a Supreme Court of Montana case from 2018. As background, the attorney, Sweeney, was representing McClanahan, who was facing drug charges. McClanahan didn't appear for a pretrial conference and was charged with bail jumping. An essential element of that charge was knowledge of the hearing, and McClanahan contended he didn't know about it. The trial court then ordered his attorney, Sweeney, to testify about whether her client knew about the hearing. Sweeney then sought intervention from the state superior court. At issue was forcing Sweeney to testify to her client's knowledge of the mishearing, a violation of their attorney-client privilege. The majority of the court held that compelling Sweeney to testify would violate their attorney-client privilege. A Montana statute provides that without consent from the client, an attorney cannot be examined as to any communication made by the client to the attorney or advice given to that client. Here, the court held that advising the client of the hearing date was inseparably intertwined with legal advice. The next case is Upjohn Company v. United States. This is a Supreme Court case from 1981. As background, the general counsel at Upjohn, Gerald Thomas, was tasked with conducting an investigation of questionable payments made by Upjohn's foreign subsidiaries to possibly bribe foreign government officials. The IRS then investigated and demanded files and information collected by Thomas. The company claimed attorney-client privilege and did not want to turn over that information. The Court of Appeals ruled in favor of the IRS, holding that only senior management had privilege with their general counsel. At issue was which employees held that attorney-client privilege with their corporate attorney. The Supreme Court here disagreed with the Court of Appeals, holding that there was a broader privilege needed to encourage employees to communicate with their corporate attorneys. The court described the factors they considered when determining that privilege. First, the communications concerned matters within the scope of the employee's corporate duties. Second, the communications were considered highly confidential by the company. And third, the communications at issue were made by employees to Thomas at the direction of their superiors in order to secure that legal advice. And so for those reasons, the court felt that even though these were lower level employees, they were communicating with the general counsel as if he was representing them. The next case is Zimmerman v. Superior Court. This is a California Court of Appeals case from 2013. As background, we have a defendant, Goodwin, who was charged with murder. Zimmerman was his public defender, and she lodged with the court a portfolio of documents that was belonging to Goodwin, which included unopened mail of his. The prosecution wanted to know how Zimmerman had those documents, meaning who had given them to her. She declined to say, claiming attorney-client privilege. The court held her in contempt, but stayed sanctions so that she would have time to appeal. At issue was, does the scope of the attorney-client privilege cover the identity of Goodwin's agent, the person who gave that unopened mail and information to the attorney? The holding is the court noted that the privilege covers confidential communications and the observations made as a result of them, but it does not protect against disclosure of the underlying facts or disclosure of independent witnesses. The court held that Zimmerman needed to answer from whom did she receive the portfolio and emails, but she did not need to answer the other questions from the prosecution. holding that these questions were not privileged information. In Clark v. State, this is a Court of Criminal Appeals case from Texas from 1953. As background, we have a defendant who had killed his wife and then called his attorney, who then advised him to get rid of the murder weapon. A hotel operator listened to the conversation, and evidence of the call was admitted into evidence at trial. At issue was whether a third party overhearing a conversation between a lawyer and his client, does it destroy its confidentiality? And then second, should the communication have been confidential at all because the attorney was advising his client to commit a crime? This court held that, at first, the court held that the privilege is lost if the communication is heard by an eavesdropper. Then, on rehearing, the court backtracked and held that we should allow privileged conversations to be held under reasonable precautions, like having a private phone call between yourself and your attorney. For the second issue, the court held that if an attorney's unsolicited advice to commit a crime can be construed as being beyond the client's claim of privilege, the loss of privilege should be limited to the crime for which the advice was given. The argument is that if the attorney volunteered advice about disposing of evidence, in this case the murder weapon, it shouldn't remove the privilege attached to the initial part of the conversation, when the client revealed the confidentiality that he had murdered his wife. However, something to note, the CEC arguably says in this situation that the whole conversation should lose its privilege. Even the beginning part of the conversation about the client confidentially telling his attorney that he had murdered his wife. Our next case is United States v. Zolan. This is another Supreme Court case from 1989, which is discussing the crime-fraud exception. As background, the IRS was investigating the tax returns of the founder of the Church of Scientology. The IRS demanded production of tape recordings between church representatives and their legal counsel. The IRS argued that these tapes fell within the crime-fraud exception to the attorney-client privilege. At issue was what evidence can a court consider when determining whether a communication falls under this crime-fraud exception. The court held that before allowing in-camera review, which is where a judge privately views confidential evidence to determine if it can be used by a party or made public or shown to the jury, a judge should first require a showing of a factual basis adequate to support a good faith belief by a reasonable person. Essentially meaning, would a reasonable person with the evidence shown think that a crime had been committed? The party opposing the privilege could use any non-privileged evidence to support their request for in-camera review. Regardless, the judge has discretion not to grant that in-camera review, even if there is a showing that a reasonable person could have a good faith belief that a crime or fraud was committed. Our last case was Swindler and Berlin v. United States. This is another Supreme Court case from 1998. As background, Deputy White House Counsel Vince Foster met with an attorney to discuss possible investigations of the Travelgate firings. The attorney had took notes during their conversation. 9 days later, Foster committed suicide. The independent counsel investigating the firings subpoenaed the attorney's notes for a grand jury investigation. At issue was whether or not the attorney-client privilege survives the death of a client. And the court held here that yes, it does. The attorney-client privilege survives the death of a client, and the attorney was not required to turn over the notes in this case.